I literally wasn't paying.
Okay, excellent. Thanks, everyone. Once again, apologies for the delays with the technical issues. I made sure we started off early, but it never goes according to plan, so I do apologize. But a very warm welcome from me to South African Patent Law and Practice and to those that are online as well. Can somebody online just give me a thumbs up that you can, in fact, hear me? Okay, we've got, thank you guys, I appreciate it. Okay, so it seems like everyone's present. Thank you for making it out to the offices for those that are here in person and to those that have joined online. Online was actually intended for those that are out of Gauteng, but it seems we have more people online than in person, but it's okay. But I do appreciate everyone joining today's session and the workshop that we're going to be together with for the next 2 days. My request to you is to please engage as much as possible. Speak to me, ask as many questions as you can. Don't feel afraid to, share ideas, to share your viewpoints on certain topics that we're going to discuss. I'm not here just to read the slides to you. There will be some things that are very theoretical, that will be quite verbatim, where I need to basically just read certain parts of legislation to you, but that's not what I want from today's session. I've been presenting South African patent law and practice for several years now. The first year that I presented was only in person. Then it was the pandemic and it was fully online. And now I've tried to accommodate both in person and online. It just makes it a bit easier for me as a presenter to actually see the faces and to see if I'm losing you, if you're tired, if we need to have a break. Simple things like that just helps me to gauge and get a sense of how everyone's doing. So for those that don't know me, I am Marco Vata, and I'm a patent attorney and partner at Spur & Fisher. I've been in practice for 12, 13 years already. The department that I oversee manages all the formal aspects of patent application. So I don't necessarily deal with South African inventors or South African applicants. It's all foreign associates that I deal with that wish to obtain protection in South Africa for both patents and designs. So my client base is all foreigners, not necessarily local South Africans, unfortunately. So just so that you get a sense of what my practice is and what I deal with. My details are all up on the presentation. My contact details are there. This is being recorded as well. And then within the next week or two, I will ensure that these recordings are posted up onto that YouTube channel. So if you do want to go back to the videos from the workshop of today and tomorrow for preparation for exams, you're more than welcome to go through the videos online. Just some housekeeping rules. Anyone that is online, to please just ensure that your microphones are muted unless you do have a question. I'm not going to be looking at my screen all the time, so please feel free to stop me and just speak up if you do have any questions. I will monitor the chat from time to time as well. Then for those that are in person, the restroom is just down this passageway all the way to the other end. So if you do need a comfort break, please feel free to exit. Then we'll break within an hour or so, and then we can have a cup of tea and some biscuits. Yes, you guys are losing out online. We've got coffee and biscuits. And then I think we can just have a few minutes to chat and to get to know one another. I mean, the people that you're seeing here, seeing online, These will hopefully be your colleagues. They'll probably be patent examiners here as well. So everyone that we will be working with. So I think it's a great opportunity for us just to get to know one another, interact with each other. So make friends today, okay? All right, excellent. Then, before I forget, I need to provide registers for everyone that's in person to the PB in Saipo. So there is a A4 piece of paper being passed down the room. Just write your name, email address, today's date. Even if you just write today's date on top, that's fine. Your signature, and then whether you are attending for Saipo or if you're attending for PEB. Okay. Are there any questions before we kick off? Guys, I had a terrible nightmare last night, I must tell you. It's been quite chaotic. So my preparedness hasn't been the greatest for today, I need to be honest, and I was hoping to get everything smashed out early this morning. And I think it was playing on my mind whilst I was sleeping. And in my nightmare, I dreamt that I actually started shouting at everyone in attendance. But I can promise you I'm not going to be shouting at anyone, okay? I'm not a monster or a bully, okay? So please don't be afraid. Honestly, I woke up horrified at the way I reacted in my dream. Okay, but jokes aside then. In terms of the examination, it is a very tough exam, guys. Please don't be mistaken that you can spend a weekend preparing for the exam. You need time to prepare well if you want to pass the exam. You would have seen from past examination papers that the questions are quite mixed. A lot are theoretical, but then there are also some practical application-based questions in the exam paper. The examination is usually between 180 to 200 marks that are allocated to it, and you have 4 hours to write the paper. So there's ample time, but you do need to know your stuff. My advice to you is to use the lecture material that is presented today as your study guide, okay? Everything that is examined is provided for in the presentation. Perhaps not in as much detail as it needs to be, but it will be your reference point as to what is required. There is 1 or 2 questions that may come up of matter that we don't cover in the presentation that is for self-study, but I will highlight that tomorrow when we deal with that section that is for self-study. Okay. Then past examination papers. It really is worthwhile working through those past examinations, getting a good feel for what types of questions will be asked, and to practice those. With that, you should do relatively okay. All right. There is also then the Dean and Dyer textbook. This is an old edition. I unfortunately don't have the new edition yet, but this is still suitable to use. There's a chapter on patents in this book and a chapter on commercial transactions, specifically the portion relating to patents that you can have a look at. It's an easy guide to work through. It shouldn't take you long just to read through that chapter. I wouldn't use it as your study source, though. It's more to elucidate any questions that you might have. Then if you really are ambitious and you want 100%, then you'll look to the Burrell's book. This isn't necessary for you to pass this. It's just the patent Bible in South Africa. So case law, anything like that, is dealt with at length in the Burrell's textbook. Okay. Are there any questions before we kick off? Yes.
Test or the mock exams from last year, are you providing a memo or are you doing a class again? How will you go through it?
Yeah. So the way that I do it is about a week or 2 before the examination date, I will set up another online meeting, so only Teams meeting, for us to get together where we work through 2 examination papers for the last 2 years. So I only deal with the last 2 years examination papers. The rest you'll need to work through on your own. But in that session before the examination, I come very unprepared for that. It's more for you to ask me questions. We will go through the examination paper one by one, but I'm not going to be giving you the answers. So you need to prepare for that and provide me with your inputs. And then from there, I will gauge what I need to touch on, where we need to fill any gaps before the exam. So guys, there is ample opportunity for you to prepare for the exam and to ask questions. I'm always available. I'm responsive on emails. So even when you are preparing for the exams, don't feel shy to email me or to even give me a call if you want to go through anything with me. Okay. Then in terms of case law, it's only the case law that's provided for in the presentation that I will be examining on. It's not much, okay? You don't need to know the case in that much detail. You only need to know what the finding was or what the test that the courts applied to determine infringement, as an example, in the examination. Okay, so purely only the cases that are provided for in the study material. Sorry, there's still a few people joining the meeting. Okay, anything else? No, just the party names is sufficient, guys. This isn't law school. I'm not here to try and trick you out with things like that. You know, if I could see you kind of got it, maybe one party name, I'll consider giving you a mark or half a mark. But I don't need to know which court heard it or when it was heard. That's fine. Just the parties is fine. Okay. Good stuff. So you guys are stuck with me for 2 days. Unfortunately, fortunately, I don't know, you decide. Okay. But we have quite a big agenda to get through. First off, we're going to do a brief introduction into the broader IP landscape and patent law. Then we'll briefly touch on international arrangements. So what treaties are in play, what agreements are at play that affect patent law, and how those international treaties and arrangements affect us in the South African context. So we'll look at TRIPS, we'll look at PCT, just to name a few, but we're not going to go into that much detail. I think you would have covered a lot of this already in other modules. So it's just more for a refresher, but don't take it for granted that you won't be examined on it. Okay. Then thirdly, we're going to look at patentability. So what are the requirements for patentability? How do you obtain a granted patent? What requirements do you need to meet? Very important section of the work. I can guarantee you more than 25% of the examination paper is based on that section alone, because we will touch on topics such as novelty, inventiveness, the tests that the courts have applied, what are some exclusions from patentability. So you can mark that on your notes as NB. Then we'll move on to procedure. Now, this is probably the most boring part of the work because it's the more formalities type of work. It's the work that I deal with on a day-to-day basis. And it is critical to understand the procedural aspects. But even though it's boring, we have to get through it because it is critical, especially in practice. That will also include your renewals of your patent rights. Then we'll move on to corrections and amendments. So if there's a clerical error in the application or the specification, we will then look at how to correct that and how to make amendments. What are the confines in terms of law for an allowable amendment, depending on the stage of prosecution of the application or the granted patent right. Then we'll look at some of the rights of the patentee, the rights of the applicant, the rights of the inventors. So the parties that are involved and the owners of either the invention or the application or the patents. Then we'll touch on licenses. So this is focusing primarily on compulsory licensing. There are two types of compulsory licenses that you can consider in South Africa. That is where there is an abuse of patent rights or where it is a dependent patent. But we'll go into much more detail tomorrow when we look at licenses. Then we'll touch on restoration. So where a patentee's lost their patent rights because they haven't paid their renewal fees timeously, how can the patentee restore their rights to that patent? Obviously, their rights will be limited. So we'll look at the limitation of the patentee's rights as well, should their patent have lapsed and they wish to restore it. Then revocation, also very important, is how would a third party attack a patent right? So where they wish to invalidate it. So there is an exhaustive list on which grounds a patent can be revoked, and we'll work through each of those in section 9. Then we'll briefly touch on infringement to determine how infringement is considered by the courts, and then appeals and offenses and penalties, there, chapter 11 and 12 are primarily for self-study. So we won't touch on those in great length. Everyone comfortable? Good. The temperature okay, Nya? Good. Awesome. Yes. Yes, it is. Okay. It's very clear from the Act what the requirements are in terms of offences, appeals from the registrar, appeals from the Court of the Commissioner of Patents. So it's not necessary for me to just read that out to you. It's quite clear from the Act. Okay. But again, if you are unsure of anything, you're welcome to. Okay, so let's kick off then with our introduction. Let me just see if there's any question online as well. Okay, doesn't seem there are any questions online. Okay, so where does patent law come from? Okay, it's a creature of statutes. It didn't just exist by nature. Us as mankind created patent law, along with all other forms of intellectual property. So where does a patent come from? Okay, being partly Italian with Italian heritage, I'm very proud to say that it comes from Renaissance Italy, which is the first form of an intellectual or patent right, rather. Excuse me if I'm mixing up intellectual property and patent. But it's the first form of a patent right that was granted, and that was in 1416, where Sir Franciscus Petri had created an invention that was used for the fulling of fabrics of wool. So after a sheep had been sheared, they would full that fabric by cleaning it out, taking out any gunk of it and fulling it, making it voluminous. So he had come up with a specific device to do that. And, at that time, you would think, well, this is something that I've created and I want to benefit from what I've created. So in Venice, they granted him this right of exclusivity to the patents. And we can't necessarily call it a patent at that point yet, but it was the first form of an exclusive monopoly right to a third or to a party to exclude others from being able to use an invention. Then in 1421, again in Venice, Filippo Brunelleschi was again awarded a right by the powers that be in Venice at the time for a novel boat design that was used to move marble slabs. Now, if you've ever been fortunate enough to visit Italy or Venice in particular, and you have a look at all the Venetian buildings, all the buildings that were created during the Renaissance, all the artwork, marble was used quite extensively to beautify and adorn these buildings for ornamental purposes. And as you can imagine, in the canals of Venice, it's quite difficult to move marble around, where you've just got water waterways. So he had come up with a boat specifically to be able to navigate the canals of Venice to move the marble slabs around. Then moving on. Okay. Okay, thank you. I've noted that. But then in 1474, so now history is not everyone's forte, but it is interesting to see where the patent law originates from, was the first form of a codified patent law, again in Venice, and that was the Statutes of Industrial Brevets. And yeah, I've got an extract of that codification. And the reason why I'm putting this up is because you can see the resemblance of current patent law, the requirements for patentability, and how it is governed. Where this was basically the foundation of current patent law that we have today. So if we have a look at it, it says each person who will make in the city any new ingenious contrivance. So we've got the reference to new. So that is our novelty requirement, because you may know that in order to obtain a patent, the invention must be novel. It must be new. Not made hereto in our dominion. So in this case, they restricted novelty to Venice, okay? In South Africa, we have an absolute novelty requirement. What does that mean? Okay, anywhere. So the invention must not have been known anywhere in the world. Okay, whereas yeah, they limited it to their dominion. As soon as it is reduced to perfection, again, a very important point that they're making here, the invention must be perfect. We can't say that inventions are necessarily perfect, but what the Patents Act requires when you're looking at the revocation provisions is that you can revoke a patent if your description does not exemplify how you need to put into effect that invention. So if you're not able to perform what is disclosed in your patent specification, it can be revoked. So very similar to it not being perfect, okay? It must have utility. So that it can be used and exercised, shall give notice, so on and so forth. It being forbidden to any other, okay, so it's excluding other people to make any contrivance in the form and resemblance thereof. So you are excluding third parties from using that invention. So very similar to what a South African patent is, patents throughout the world. You are excluding other people from using that invention, okay? From making that invention, from importing that invention. So various things that third parties are excluded from. So it's not a positive right where you are given as a patentee a right to do something. It's a negative right, as we refer to it, because it is excluding other people from performing certain acts over that invention. So very similar to the foundation of the Statutes of Industrial Brevets from Venice. Then without the consent and license. Now, isn't that interesting? From a commercial transaction, right? It's allowing the patentee, the owner of their rights, to give somebody consent to use their invention and to license it, okay? Which is exactly what a license is today. It allows a third party to use that invention where they otherwise would have infringed, apologies. Up to a period of 10 years. So again, it was a limited duration from which they could exploit the invention of 10 years. Today, we have a 20-year limitation, okay? So the exclusive monopoly right is granted for 20 years in today's age. Who shall infringe be forced to pay with him the sum of 100 ducats and the contrivance immediately destroyed. So again, this provision from the codified law provides for infringement. So what happens if somebody infringes my rights? well, you got to pay me my money. So damages, as it would be today, or to have the articles destroyed. Okay. So delivery up of infringing goods in terms of South African patent law. So that's why I really enjoyed showing this slide, because you can see a lot of what current legislation or how similar current legislation is. It's obviously far more detailed than today, but the foundation is the same from more than 500 years ago. That's then just an illustration of what the codified law looks like from 1474. Okay, so now we have a bit of the history. What is the importance of intellectual property? Why do we want these rights? What is the value of these rights? Come on, can anyone give me their opinion? Anyone? What is intellectual property? Why do we have intellectual property? Okay, that's a good answer. Any others? Okay.
Also to prevent others from exploiting such rights.
Okay.
It grants others monopoly or temporary monopoly applications to facilitate inventiveness in society.
Okay, great. So we've had 3 examples here for those that are online. It's to allow for creativity, to protect creations, again, to prevent possible infringements, and then to drive innovation, basically, which is what the participants here in the office sent. But then we also need to consider the value that intellectual property has today. Okay. If you have a look at the slide that's up on the screens at the moment, sorry for all these Teams messages, guys. If you go back a few years, 5 decades or so to 1975, there's a difference between the gray and the blue. Those that are highlighted in gray are tangible assets, and then blue is intangible assets. Okay, so what are the differences between the two? Tangible assets are fixed, something you can see, it's something you can feel. Intangible is not. That's the opposite of what a tangible asset is, such as intellectual property rights. That right is an intangible asset. The products of the intellectual property might be a tangible product, okay? So you have a patent for an insulated flask. Okay? The right is the patent right for the invention. That is the intangible asset. This is the product of that patent, okay? To distinguish between the two. And the reason why I want to demonstrate to you the difference between the two is because if you look at 1975 to 2018, where assessment was done on the S&P 500 companies, which is a benchmark that is used in the United States of the top 500 capital companies, looking at their value and where their value was within those companies. So if you look at 1975, you can see that the top 5 companies there, the richest companies, was IBM, ExxonMobil, Procter & Gamble, General Electric, and 3M. And most of their wealth was sitting in tangible assets, okay, so physical assets. Then when you move on to 1985, you can still see the same, well, there's been a slight shift in the companies, but their assets were still sitting within the tangible. Then when you move on 20 years, with the boom of the computer communication, ease of communication throughout the world, the introduction of the internet, there's a massive shift from the top 5 companies of the S&P 500 in where their assets sit. So the blue now outweighs those that are in gray, and so on and so forth. And I mean, you can see it has just skyrocketed exponentially. And you'll also see the types of companies, how they've changed over time from their types of technology. If you're looking at 2018, you've got the likes of Apple, Alphabet, Microsoft, Amazon, Facebook, okay, or online presence, some technological investment that they have. Okay. But intangible assets are not only intellectual property, but of how many are these? 7, 8 types of intangible assets that were classified. 5 of those are all intellectual property related. So those are the likes of your patents, your copyrights, trade secrets, trademarks, know-how, goodwill that is perceived by the public, data, another one. I mean, everyone says data is the new currency, and it speaks truth. So of the 8 types of intangible assets that were identified, 5 of those are all related to intellectual property. So this shows the worth that intellectual property has. Okay. I mean, if you think of global brands, your Coca-Colas, McDonald's, Amazon, all of these are massive, massive brands, and their value is held within their intellectual property. Okay. Coca-Cola for their trade secrets. The others all for trademarks. Okay. Or whatever patents they have. Possibly Amazon has several patents for their algorithms to identify what products you should be buying. Is everyone still with me? Okay. Now, up on the presentation, can anyone identify what that product is? Excellent. That was the first patented light bulb of Thomas Edison. There you go. There we go. Okay, a very simple invention. At the time, it obviously wasn't, but if we look back at it now, it probably is quite simple. And he was granted the patent right in 1884, the invention, which is the light bulb today. And it was an electric lamp for giving light by incandescence, consisting of a filament of high resistance, made as described and secured to metallic wires. Okay, so that's basically just the claim of that patent in the US. But it was a glass bulb with a filament that could conduct electricity, that would incandesce when a current was passed through it. Boom, there was your light bulb. Now I want you to think about the light bulbs today. You know, if you look at these tiny little LED lights, you know, how we've come from the Edison light bulb to the light bulbs that we use today, and the improvements over that. And the point that I'm trying to make by this example, that a basic invention has driven technology so much more forward. Okay. And that is also one of the fundamental purposes of patent law, is that it is a driver of innovation. And why is it a driver of innovation? Because with every patent application, you have to submit a specification which describes what the invention is, how the invention works, and how you would perform that invention. How do you put it into practice? And that becomes a public document once the patent is granted, or within other prescribed time periods that we'll have a look at later on. But that document becomes a public document. And in return for that public document that you are lodging with the patent office will grant you that exclusive monopoly. Why? Because you are disseminating technology. Anyone has access to that invention. They know how you performed it. they know how to use it, and they know how to improve it. Okay. And that's what one of the fundamental purposes of a patent is. It's a driver of innovation. Okay. Yes. Yeah. So that's the quid pro quo principle. Just the question that the gentleman asked was, must there be disclosure in order for the public to get access to it and to drive that innovation? And that's the quid pro quo principle. So tit for tat, I give you this, you give me that in return. Okay, so in order for an inventor or the owner of that invention to be granted that patent right, because remember, a patent right, it's an exclusive monopoly. Only you as the proprietor of that right is able to exploit it for 20 years, excluding everyone else. Okay, that is incredibly anti-competitive. Okay, you're not allowing, I've noted you, thank you. You're not allowing anyone else to exploit that product. Okay, so it's anti-competitive by its very nature. And that is why it is limited for a period of 20 years. But in return for being granted this anti-competitive behavior of a monopoly rights over the invention for 20 years, you need to disclose that invention. And you disclose that because you're adding to this pool of technology, you're disseminating knowledge, you're putting out into the public domain what it is that you have created. And that is how we got from this light bulb to the LEDs that we have today. It's because there are gradual improvements. Now, something that I want you to put out of your minds is that for an invention to be new, it doesn't need to be groundbreaking new, guys. It needs to be an improvement over what already exists. If that improvement didn't exist, then there is novelty. It's not that the whole item needs to be new. Okay. Does that answer your question? Okay. The lady over there?
In the 20 years where I own the initial patent, who then owns the rights to the improvement?
Okay.
That's part one of the question. And part two is, if I have created something, I've got an idea, and let's say in the context of underprivileged people doing more about intellectual property protection, if they then take the idea to like Bidvest or whatever, who would then own that patent if it really is groundbreaking or not?
Okay. So the question was, I'm just repeating for the participants online, is whether there is an improvement over an existing technology, who would own that improvement? And then also, if the invention is disclosed to a third party for funding, as an example, who would own the rights in that case? So for the improvement, it can be anybody. The person that came up, well, not anybody, but the person that came up with that improvement is the owner of that improvement. Okay.
They have to cite the first.
They don't need to cite it. There's no need to cite it. After 20 years, it's fair game for anyone to use that product. But even during the existence of the life of the patent that's already granted, and you've made an improvement during the existence of that patent right still being in force, you can still obtain patent rights, provided that that improvement is new and didn't exist. And it doesn't need to be the same proprietor of the first patent. This is where we'll start looking at compulsory licenses, where there's a dependent patent, where you have to rely on the use of somebody else's patent in order to put into force your patent rights. But we'll touch on that tomorrow. Then if there's a disclosure from the inventor, somebody that doesn't know to protect their rights, that becomes a bit more problematic, because you have to consider who have they disclosed this information to? Have they disclosed it to the public? Because if they've disclosed it to the public, then you've destroyed your novelty. That's one of the requirements, okay? It must not have been known to the public. And what the public is depends on the circumstances as well. Where it is a closed meeting and you are looking for investment, then it's likely not a disclosure to the public because it's a meeting behind closed doors. You're having this discussion in confidence with investors. The rights will still belong to the inventor, the person that went forward to try and seek this investment, unless there is an agreement between the parties. So, for instance, where you say Bidvest, so if Bidvest says, I will put up 2 million rand in order to fund you, but I then want a 20% stake in whatever profits are generated from the patent, then that would become a contractual agreement, and Bidvest would be a co-owner with the inventor on that patent.
So if we had a community science fair, then was that disclosed to the public? Would that be public?
If you are exhibiting at a science fair and you are disclosing the elements of your invention which are considered to give it novelty, then you've lost your novelty. And this is why it's very important, especially, I don't know who's all practitioners here, but if you are in practice one day and you have universities as clients, as the prime culprit, researchers and professors at universities are ranked based on number of publications that they publish in a scientific journal every year. Okay, so their drive to get recognition in the international community as a scientist or an engineer, whatever their case may be, whatever their field is to disseminate that information and to do it as quickly as possible so that they can get ratings, they get more funding from government, they get more funding from international organizations, right? The problem with that is they completely forget that intellectual property exists. Okay, so there are quite a few articles on this, publish first, patent later, patent first, publish later. You always need to consider what intellectual property there might be in any research that has come out from a university or research institution to ensure that it's protected. So that you don't go at the university expo and publish, they always got those lovely placards and posters of their research. You have to be very careful what you put onto that so that you don't destroy the novelty. Yeah.
Sorry, Marco.
Yes, sir.
Is there by any chance any case law that deals with the question of publication and what constitutes publication or what would constitute the public, just on this score that has been traversed now?
Yeah, there is a case. If I remember the citation correctly, it's Brickcore Precast. I will double check that for you. It used to be in my slides. I took it out some years ago. But there is case law that specifically deals with what is meant to disclose to the public. So you can have a look at that case. Just if I don't provide it to you by the end of today, just remind me to give you that citation. But there is case law on it. Okay.
Thank you.
Pleasure. Then the lady in front here, you had a question?
As to whether like an improvement, yeah.
So that's debatable, okay? Because an improvement doesn't necessarily mean that that improvement is inventive. In order for something to be inventive, it must not be obvious to a person that deals with that technology. So it would have to be put to a test to determine whether that improvement is actually inventive, because it has to go a step beyond. Or even, I don't want to say a step beyond, but also a sideward step. And what I mean by a sideward step is if that product can be manufactured using a different method, but where that different method has benefits to it. It might be more cost effective, it might be quicker to do. You're still getting the same product at the end of the day, but the manner in which you're doing it is different. So that is an improvement. And whether it's inventive, that is determined as to whether that is something that would have been obvious to a person that deals with that technology. Okay. Okay, any other questions?
So after 20 years, that means that position, I would say it's nice to say, because I know trade plan obviously, but concept UK. But what happens from patient side of things? I don't actually. So can you get additional protection by having improvements to the same patent or what happens on the
Yeah. So after the 20-year period has expired, the patent register, so the patent office should mark the patent register to indicate that the patent is expired, so that anyone in the public knows that they are free to use that invention. Okay, so it's anyone can then use that technology after the 20-year period. If there is an improvement made on that, you would have to refile a new application. Okay, all right. Yes, Lisha.
Since the patent is fixed for use after 20 years, can the public request the specification from CIPC? Okay.
So the specification can be requested once the document should be open to public inspection. Now, when the official file at the patent office becomes open to public inspection, depends on what type of application it is. So just for the benefit of the online viewers, the question was, when can somebody access the patent specification? And we will touch on this throughout the course of the lecture as well. But in most cases where it is a straightforward patent application that is filed, then it only becomes available to the public once it is granted. Okay, so once the patent office grants it. Where it's a national phase application that's already been published internationally and it's filed in South Africa, it's already open to the public, okay, during the international phase. So as soon as that application is filed in South Africa, anyone's already got access to it, okay? So it depends. So that information doesn't become available after expiry. It becomes available much, much earlier. So the latest would be at grant. Just want to see if there's some questions. I can hear the pinging here. Thomas, you mentioned that there's no video. Has the video been restored? Okay. I hope it is. Okay, just some other silly examples of patents that were previously granted. Who can identify what this product is? Lego. Okay, you may have stood on that as a child and been like, this is the worst excruciating pain you've experienced in your life. Okay, so there was a patent granted in 1961 for the Lego brick. Do you think there's any other intellectual property that's still at play on this brick? Okay, I see some nods, nodding heads. Okay, but tell me what it is. Okay, possibly copyrights. I mean, copyright's usually 50 years in most cases from the death of the author. So might still be. I mean, this was patented in 1961. If the author is still alive, there might still be copyrights. Then I heard trademark. Okay, trademark, great answer. Why trademark? For that? For the shape. Exactly. remember, a trademark can also protect a shape. Okay. I also heard a design. Look, a design would have expired as well. Design's only 15 years for aesthetic. Okay, so your patent rights would have expired if this was granted in 1961. The design rights would have expired. There might still be copyright. And if they've renewed their trademark for the shape mark, there's definitely still a trademark over that right. Okay, you need to start thinking when you're dealing with your clients as to what intellectual property there is in a product. Okay, we can't just be advising file a patent. We need to think about other forms of intellectual property that we can maximize the term of protection. Okay, they will be eternally grateful. You will have a client for life. Okay, another one over here. That's the Gillette razor blade. And then this image is flipped the wrong way. But can anyone tell me what they think this is? Turn it 90 degrees. Exactly, the Wright brothers' first manned aircraft, which was also patented. Okay, so some very cool, fun inventions that have come out. Okay, so those were mostly American, I don't know, Legos from Sweden, some country like that, or the Netherlands. I'm not entirely sure. But what about South Africa, guys? Some very, very cool inventions that come out of South Africa, okay? It's something for us to be proud of as South Africans. The first one up on the screen there is Pratley Putty, which was the world's first epoxy putty, which was invented by George Pratley, in fact, easy, in 1960. Okay, and this was used, interestingly, on the Ranger spacecraft that NASA sent up into space and landed on the moon in the mid-1960s. So South Africa got there before Mark Shuttleworth. You can't have claim. We sent Pratley to space first. Okay. Then we've got the Smart Lock safety syringe. Okay, you'll remember a few decades ago, the HIV pandemic was quite real in South Africa and the rest of Africa. And transmission of HIV was very fast, and also amongst medical practitioners. Okay, when they were dealing with a patient that might be HIV positive, they might infect themselves with the virus. So South African inventors that had come up with a Smart Lock safety syringe that would prevent a medical practitioner from accidentally pricking themselves with the needle that was used to draw blood from a patient. Okay, and that then immensely reduced transmission of the HIV within the medical fraternity. Okay, then we also have Sasol's technology. Sasol's multi-billion rand corporation. You would have seen their headquarters in Sandton in their nice building. And also, they've set up shop in America and all else. But Sasol is known as the world's first and largest oil from coal refinery. So that's the technology that Sasol developed, okay, and what they're known for. So again, patented technology. Interestingly, Sasol has a massive IP team that works in-house. I think they've got more patent attorneys than Spur & Fisher does. Okay, then Q20, another South African invention. I'm sure if you've got a squeaky door, do you want to lubricate, you would have used Q20. How did Q20 come about? Anyone? Fun fact. Volkswagen Beetles were very popular back in the day in South Africa, and they were known for stalling in wet weather conditions. Okay, there'd be water that would go into the distributor caps of the VW Beetle, and this owner of this VW Beetle was tired of this happening, So he had come up with this water displacement in Q20. Okay, so where there's a problem, there's always a solution. And this is a prime example of one of those. Okay, so very nice one. This was developed in Pinetown in KZN by Robertson. Guys, the introduction part's all fun stuff. We're going to get into the serious things, okay? Then again, very important, medically used across the world is the CT scanner. Again, developed in Cape Town by two physicists, Alan Cormack and Godfrey Hounsfield. So I think this is groundbreaking stuff that's been developed. Okay, importantly, the Dolos. I'm sure if you've been to the coastlines of South Africa, you would have seen one of these. Sadly, the Dolos was never patented. And I mean, this thing is used across the world along the coastlines to prevent erosion due to the water breaks on the coastlines. Okay, so again, a prime example as to why patents are so important is because the inventor of the Dolos could have been a multi-millionaire had he protected the Dolos, but it wasn't. Okay, and it was made public knowledge and used across the country and elsewhere in the world now without any form of IP protection. And then the creepy crawly, right? Again, another South African invention, which is a pool cleaner used across the world. So there's quite a bit happening in South Africa. There's not enough happening in South Africa. Funding isn't the most prevalent, unfortunately, for research institutions, but there's a lot of brains in this country, and we need to appreciate that and also encourage people and also create IP awareness. Because like the lady mentioned, somebody that isn't aware of IP doesn't know that they have something that is actually valuable. Okay, and that's another point that I want to make when you consider intellectual property as a whole and also patents as a subclassification, is that when we're looking at those graphs of the S&P 500 companies, IP is an asset. Okay, we have established it's an asset. And the way that you deal with these assets is the same way you would deal with it as a tangible product. So a simple analogy, you purchase a house, okay? You have your house, it's probably your biggest asset that you own. You own the house, okay? You decide, I want to rent out the house to another party, okay? If we bring it back to a patent, you own the patent rights, but you want somebody else to use it, okay? To rent out your house, you're going to enter into a lease agreement. You can use my house, but you're going to pay me 5,000 Rand rent every month. Similarly, with a patent. I own the patent. You're welcome to use it. You're welcome to manufacture it, but you are going to pay me royalties for whatever profit you make off of that. Okay. So you see how tangible, intangible assets, they work the same. Okay, the effect is the same. I can sell my house if I'm tired of living in the neighborhood. My neighbor's irritating me, their dog doesn't stop barking, I'm moving. You decide to sell it. The same way, I have a patent that is of value. I don't have the manufacturing capabilities. I'm old. I don't want to deal with this type of admin and stress. I can sell that patent right to a third party by way of a sale agreement or an assignment agreement. Okay. So don't think of it as something that exists in space. All right. It is dealt with the same way you would a tangible asset. Another question.
They have a common that exists.
So the question is whether for the Dolos there was a common law form of protection, and I'm not aware of any common law rights. There might be competition law that you could probably argue, but I think it's quite a thin argument. But there's no common law. It's purely, these rights are statutory rights.
So does that just belong to the public?
Yeah, Okay, then we had a not so wonderful, the Americans, they come up with all strange things sometimes. Yeah, you've got an anti-eating face mask. So this was specifically developed for a chef. He's constantly eating and tasting and ends up looking like me with a bit of a belly. Once a bit of it. So this mask would be locked or used to lock your mouth so that you couldn't actually eat anything. That's absurd, but that's new. It's inventive. He's got a right. Whether there's actual value to it, I don't think so. You don't want to be walking around looking like Bane. Okay. So a lot of this I've touched on already, the nature of intellectual property rights. These are concepts that are created through innovative and creative efforts of the human mind, which the lady mentioned earlier. So intellectual property, it's exactly that. It's property of the intellect. It's something that you have expelled some ingenuity into and have created and developed something. As I mentioned now, there are also statutory rights. So they are all codified, except for when you're looking at trade secrets. No codification of that. The rights are territorial. Okay, very important to note. There's no such thing as a worldwide patent. If you thought that, then I'm a bit concerned, but there's no worldwide patent. There are mechanisms by which to obtain more widespread protection across the world, but you don't get a right in all those countries if you file for patent application in South Africa. Okay, and you've got to think about this logistically. Every country is a sovereign state. They have their own sovereignty to maintain. Every country has their own laws. Okay, because the patent right that is granted to you by the South African government. Okay, so the South African government can't overstep and grant you a British patent. Okay, so that's why these rights are territorial in nature. So you need to seek protection in every country where you wish to protect your rights, and this is where it becomes a very costly endeavor. Okay, then, as I mentioned, they're intangible in their conceptual form, but can be rendered into intangible products. They exist separately and independently of their creator, so they're not attached to you. Then they're assignable to third parties, which goes to the point that I mentioned. You deal with it as you would a tangible asset, so you are able to sell it to a third party, and the Patent Act expressly provides for that. Then capable of being commercialized and have economic value, so that is the primary benefit to the proprietor of the invention, is that they are able to hopefully obtain just reward for their ingenuity, their creativity in developing a certain product. Then whether patent is immovable or immovable, in terms of the oil well case, it was held to be an immovable property. Okay, so it's fixed within the confines of South Africa. And this becomes very problematic if you are a South African owner of a patent and you are selling it to a French-owned company that is based in France, okay, because of this provision of it being immovable. Okay. But the issue more, though, is the exchange control provisions. Okay, so any capital that leaves South African borders requires exchange control approval from SARS. Okay, so SARS needs to agree to you selling your patent to a foreign entity. Okay, they're very happy to take in somebody selling to South Africa. It's fine, bring it. But as soon as you try and move capital outside of South African borders, you need Reserve Bank clearance approval. Okay, so you need to make an application to the Reserve Bank. They can, and they have. It's wealth leaving the country. That's the primary thing. So they also want that wealth to be retained in South Africa. So you can sell it to another company, but what is the country getting in return in terms of the GDP and the overall status of the country's welfare. So if you are licensing it to a foreign company or you're selling it to a foreign company and they are not paying you what the value of that is, then SARS is not going to permit it because you're not getting in return what you should for that product. Okay, so it's got to be fair value at which you're selling that right. Otherwise, they will refuse it. Also, where it's not in an arm's length, so it's a related company, you're just shuffling, you're trying to evade tax, sending it to the Cayman Islands, things like that, where it's a company housed in the Cayman Islands. They're not going to allow. Okay, so they should be unrelated companies. So the purpose of SARS, the revenue services, is to collect tax. SARS regulates the monetary policies and the money that is held within the country. So that's why it has to go through the Reserve Bank, not through SARS, because this isn't tax that we're dealing with. It's an income. That makes sense.
You say who's collecting the Reserve Bank or SARS? You're saying SARB or you're saying SARS?
The Reserve Bank. Reserve Bank. Yeah, SARB. Yeah. Another question?
So you're saying that a patent is in, and by that you mean, let's say you filed your patent application and you have a specification. That is the part that is in the law, but the product itself that came from.
Yeah, the products you can export and import as much as you want. Yeah. Okay. Another question?
SARS, some bank will the patent be removed from the patent list in this?
No, so it's still a South African patent. So the question is, will the patent, if it is transferred to another company outside of South Africa, if it's approved by the Reserve Bank, whether it's removed from the register, that asset is still a South African patent. So it stays on the South African patent. It's renewed as a South African patent. It's just who owns that right. Okay, so who's the owner of that patent that would change? So who's benefiting from that patent? Is it a South African company or a South African natural person, or is it a foreign company? Yes.
So just like the patent, like naturally is in your.
Yeah.
But if you lease it overseas and you're getting sufficient rights that are going to the South African companies, under those conditions, it can be classified as.
Yeah, that's exactly. Yeah, no. It is a bit of a gray area the way that it's dealt with, but that's pretty much the summary of it. Okay. The reason why this became problematic is because the Reserve Bank regulations that deal with exchange control approval held that you need exchange control approval where there is capital leaving South Africa. Now, what is capital? Is intellectual property capital? I wouldn't really think that it's capital, right? But then the Reserve Bank was forcing people to think that intellectual property is capital. There was a case that was heard, I think, by Judge Harams that said intellectual property is not capital in terms of the exchange control regulations. And the Reserve Bank was not happy about that, right? So what did they do? They amended the regulations. Said capital equals intellectual property, amongst other things. Okay, so they clearly defined it. And that's why we have to go through these exchange control hurdles when we are exporting the IP of South Africa. Okay, guys, I think we've touched on a lot of this what is it, a patent? So just a dictionary definition, an agreement between an inventor and the government of a country in which the inventor agrees to publish his or her invention. In return, the government agrees to give the inventor exclusivity on the use of the invention for a limited time. Okay, so I think we've touched on that quite clearly. But ultimately, it's in a statutory monopoly right that provides for the protection of an invention to exclude others from exploiting that invention for 20 years in South Africa. But in return, in terms of the quid pro quo principle, they must fully disclose that invention. Okay, then just to recap again, what is the purpose of a patent? Who wants to spell it out again? Huh? What's the purpose of a patent? Okay, we're protecting the invention. Two? Okay, to got the rights. Oh, commercial value, right? What's the other one I spoke about? Why do we disclose? So, to drive innovation. Okay, we're getting there. You guys are doing good. Okay, that also encourages improvements in technology. Reward such improvements if there is commercial value for that invention. Okay, because I can assign it, I can sell the patent to somebody else for X amount of money. I can license it to a third party to manufacture it, and they provide me with royalties on every sale. Then to obtain disclosures. It also encourages the application of technology in the country. You must know, if you have spent money on doing research and trying to protect this invention, you want to get as much money out of that invention that you have created. So you're going to market it, you're going to push it, it's going to encourage people to use it. And everybody wants the latest tech, you know? We want to make our lives easier, and that's what technology does. So it drives the application of technology in society as well. I mean, we're not sitting in the caves making fires anymore, right? We're turning on our gas hobs. Then it's also, very importantly, a deterrent to infringement. So it protects against infringements. If somebody sees that you have a patent, which is a prima facie right, that you are the owner of that patent, they are hopefully less likely to infringe on that rights because they don't want to be sued for infringing the patent. Okay, so this is again going back to the Edison light bulb as an example. So if you think of the incandescent light bulb, we moved from carbon to tungsten, which then, obviously from the fire to the candle, you know, the improvements you can see to paraffin. Then we moved from carbon to tungsten light bulb over here. The purpose for that was because tungsten has a longer lifespan. Okay, so there's an improvement in the technologies. There's a benefit to the public in using tungsten as a material over carbon because it lasts longer. And then it was cheaper. Then we moved on to fluorescent light bulbs, which compared to the tungsten light bulb had 10 times longer lifespan as well. So you weren't changing light bulbs so regularly. And then lastly, moving on to the LED light bulbs, which we also know have a much longer lifespan today. They use far less electricity as well to run. It's because of the light emitting diode, which is what LED stands for. So far more cost effective. So you're saving twofold, yeah. It lasts you much longer, so you're not having to replace light bulbs all the time, but it also uses far less electricity. So your bill to Tshwane municipality will be less. Okay, so you can see the drive in technology over time. I see we have a question here, so I'm just going to toggle between the screens. Luke's asking, sorry, Marco, can I just confirm the principle in terms of IP as immovable property? Wellward concludes that IP is a territorially fixed asset that cannot be exported, but foreign ownership would trigger exchange control provisions in the necessary. Yes, that's exactly it, Luke. Yeah. And this is then what the South African government will issue you once they have decided to grant your patent. So just an illustration of what the patent certificate looks like and which can then be used as prima facie evidence that you are the owner of the patent. Okay, and that brings us to the end of our introduction. It's quite a long introduction, but I hope it's whet everyone's appetites for what's to come, because we're going to get down and dirty in a few minutes. Any questions before we break for a few minutes? Okay, so if there's no questions, I think let's just break for 15 minutes for a comfort break, just to grab some water or anything. So let's resume at 11:45 then. We will look at international arrangements. Okay, so everyone online, we'll see you at 11:45. Thank you.
That's good. Great minds, I mean, it's. Can you see, right?
Yes, I would say that.
So, not from Italian as well.
Yes, all of the time.
Oh,
Yeah.
so, what in Italy? Yes, but
Yeah. Yeah. Very Italian fast food. That's the stuff. I have very fun.
I should, this,
Really?
I walked the best. Yeah, it's always.
Still get tourists coming every day. Pictures of it. That's. Yeah, we could get paid to eat it. Yeah.
How much is
No, VW is obviously in my car.
Yeah. That's all the previous, I think last year was. Previous year was previous, yeah. And then that should learn also. That's why I wanted to move over to personally. Just to stand there and talk to the screen. It's like when it's a lost formation. Yeah, that's exactly. That's very important. There's no notion lost. Not lost on the for this person, I mentioned very clear on this. For a lot of these, also from more the pitched proposals, you have to always have your budget. Yeah. So I would propose how I'm going to design this classroom. Yeah. If it works as a disclosure is exactly mentioned. Yeah. So is that right? That's not necessarily a public disclosure. But it will fit within the confinement. It's a concern. It will come inside the university. Yeah. Sometimes it's not. I don't think that. So I think it's very confined.
Sit tight.
So that points. It's actually the actual runs, or if that's or such a child purposes. So if you actually do already watching the property seal contains so they are protections of those. So I know the but if you take the final and put it into the difference system here, then the policy is that same to the process. Is it different? So that we have gray areas in I mean, the technology is sort of. But so there's no problem with that. Yeah. Problem comes in is that text. Yeah, that's going to fit you. That's it. That's the talking to Congress. Oh, it's so but the products are like cheap. There was no question. It's confusing. When it comes to one, reading one, it's my friends. So. So I mean, it's not okay. There's no. South African.
Okay.
Use this one. So,
But you know some people that
No, it's not gonna allow not respond. There's a tool on employment. So let's say below time.
Yes. That is right. My sister stuff over on some especially around students That's it.
Yeah.
So that's up to you. So that's it.
Okay. So I don't think so we yeah, for since it was 3 yeah, yeah. It was 324. That's right, for 322. How's it been? Are you still with this? Same, same. What? Oh, okay. Okay. Okay.
Okay, welcome back, everyone. Is everyone comfortable with the pace that we're going at? Am I going too fast? Am I rambling too much? No? Okay, everyone happy? Thanks, Tashmika, for the thumbs up there. Okay, so we'll move on to international arrangements. This won't be a very long section. Just going to touch on which treaties to consider, where they affect patent rights or patent laws. So the first being Paris Convention, which I'm sure many of you are familiar with or would have come across in your prior studies. The Paris Convention, apologies, I just need to switch this around. Side. Okay, so there are three main principles that come out of the Paris Convention. And that is the principle of priority rights. And this you deal with extensively when it comes to patent applications. Now, what is the principle of priority rights? It allows an applicant to file a patent application in one of the contracting states to the Paris Convention. But it allows them a 12-month period within which to obtain patent protection in other Paris Convention member countries. Okay? So if the applicant is an American and they are filing their American application in the States, but they also want to protect that right in South Africa, they have 12 months from that first filing in America to file the application in South Africa, where novelty and inventiveness will not be destroyed. Okay, so in the application, you will claim priority from the US application. Does that make sense? Okay. So when a court assesses novelty and inventiveness, if ever it comes before the court, they will look at what prior art, what technology was available in the public domain before the priority application filing dates. Okay, anything that came after that does not form part of the prior art. So the courts, if they are assessing novelty and inventiveness on the South African application, they won't look at the South African filing date to determine what was novel and inventive before the South African filing date. They will look at the priority application filing date. Okay, so you've got 12 months from filing your first application somewhere else in the world to file it in other contracting parties. And that is one of the main principles that comes out of the Paris Convention. Then there's also the principle of national treatment. So member states must grant the same protection to nationals of other contracting states that it grants to its own nationals. So you can't have favoritism where, because it is a US applicant, that they have more rights than what a South African applicant would have. So the rights should be equal for all contracting states to the Paris Convention. Then it also has a set of common rules which are aimed at harmonizing laws in different contracting states. Okay, we're not going to delve into that, but it just tries to unify intellectual property rights across the member states or contracting states. The Paris Convention is administered by the World Intellectual Property Organization, and South Africa became a party to that convention on the 1st of December 1947. So we've been party to that for quite a long time already. Okay, the next being TRIPS, the trade-related aspects of intellectual property rights. Again, this touches on various forms of intellectual property, predominantly copyright, but it also has three overarching principles. One, again, is that minimum standards must be established amongst contracting parties. So very similar to what the Paris Convention tried to obtain, with national treatment as well, and then most favored nation treatment. So if one country's laws have better benefits, that is the benchmark. So the most favored country's rights is the benchmark for all contracting states. Okay, so that was just codified then with TRIPS. But TRIPS, you don't need to worry about too much when it comes to patent rights, except that created this minimum standards, again, national treatment as with Paris Convention, and then the most favored nation treatments. TRIPS is not administered by WIPO, it's administered by the World Trade Organization. And South Africa has also been a member for many years. And probably the most important treaty that we deal with today is the Patent Cooperation Treaty, or otherwise the PCT, which is specific to patents. So what the PCT does, it allows for a unified procedure for filing a patent application in order to protect that invention in contracting states of the PCT. It doesn't grant you a worldwide patent rights. It just simplifies the procedure in which you are able to obtain patent rights. There are several benefits to filing a PCT application, which we'll touch on. The first being that it is likely, even though the initial application for PCT application is quite expensive, in the long run, it will be a cost benefit to an applicant. And it will all make sense as we work through the way the PCT operates, which we'll look at in a little bit later. So as I said, it's an international application that is filed at WIPO, which is administered by various patent offices across the world as a receiving office for the application for the PCT international application. But you still need to nationalize that right in every country where you seek to obtain patent protection. What is important about the PCT international application is that that application undergoes examination. Okay? So the International Searching Authority, or the office that you have elected to examine that application, will examine the international application. So once you've filed your PCT application, an examiner that is qualified in the technology related to that invention will examine it to determine whether that invention is novel, and whether it is inventive, and whether it is industrially applicable. Okay, the three main principles of or requirements to obtain a patent. And they will then issue the applicant with a written opinion. In that written opinion, they will stipulate whether they deem that invention to be new, whether they deem that invention to be inventive or not. So you as the applicant, prior to spending money in filing individual patent applications in various countries, will already have a good assessment during the international phase whether that invention is new and inventive, and whether it is worthwhile nationalizing it in various other countries. Okay. Does that make sense to everyone? Okay, excellent. The other benefit is if there is something that the examiner has pointed out that they deem is problematic in the specification. So they might say that your first claim is not novel. Okay. But your second claim, there's something in there that you have set out which is novel. It allows you as the applicant then to make an amendment to that application during the international phase before it is nationalized. So you can then overcome the objections that an examiner has raised during the international phase to amend Claim 1 with Claim 9, where Claim 1 wasn't found to be novel, but Claim 9 has something that is novel. You combine the two claims, you amend it. This is just a hypothetical example. And then your Claim 1 is novel because there is a novel integer found in there. So you've overcome the examiner's objections, you amend the specification in the international phase, and then you nationalize it. So why is that important? You don't have to amend it in every country after you've nationalized that application. That amendment that is made in the international phase is, in the South African context, deemed an amendment allowed in South African law. And that is the case with most contracting states to WIPO, to the PCT. So you're saving costs by already nationalizing an application, which you know has an opinion from an examiner that the invention is novel, that it is inventive, and you've overcome an objection. All right. So there's a cost benefit to being able to, firstly, get an examination report before you nationalize it, and knowing whether it's worthwhile to protect the invention in other countries, or you know that the invention is novel and inventive, or there is an objection that you can overcome by way of it. Okay. I know it seems very grey to a lot of you at the moment, but as we go through it, will start making a little bit more sense. Okay. South Africa acceded to PCT on 16 December 1998, so we've been utilizing PCT for quite some time. It was implemented in March 1999. The benefit of the PCT, as well, which is highlighted here, is that it makes the filing a lot easier across various countries. So there's a lot of transfer of technology from one country into another country. Then there's about 157 member states that may have changed recently. The most recent country to join PCT, as far as I recall, is Mauritius. Okay, and that is administered by WIPO. Then there are some, yes, a question. Okay, so with the filing of the PCT application, the question is, where do you start with it? So the South African Patent Office is a receiving office. So they are authorized by WIPO to receive and process that application. Okay, but it forms part of an international application. So they're able to accept the application, but it forms part of the international application by WIPO. Yes, so their systems are then linked to communicate with each other. Okay, so you can elect where you want to file it. You don't But for South African, you would choose to file in South Africa Patent Office because it's
So when it's
Easier.
a national, it's national in South Africa.
not national at that stage yet. It's only an international application at that point. So you still need to nationalize into South Africa once the international phase has been processed.
Okay, so it's done there,
Yeah,
and then you find.
into South Africa. Yeah.
Okay.
It's just that our patent office is able to process the international application. But we'll go through the slides and we'll go through all those steps so that it's much clearer, it's illustrated, and it will make a lot more sense as to the various routes that you would follow. Okay. Another question, yes. Or trademarks. Okay, so the question is whether PCT is similar to Madrid. Not necessarily, because with Madrid, you can designate countries. I'm not a trademark expert, so correct me if I'm wrong, if there are any trademark practitioners there. You would designate the countries where you want to protect your rights. Okay, so once it is granted, those rights are granted in all those countries where you have designated the rights. With PCT, you don't do that. You still have to nationalize it in every country. Okay. There are other patent systems that are similar to Madrid, which we'll touch on shortly. Okay, but it's not the same. In terms of the filing process, that's similar and what happens, but to obtain a vested right in every country is different. Okay. Then a question at the back.
The inventiveness lay that side. If you encourage them entering the national phase, maybe South Africa, would that have happened?
Okay, so the question is if during the international phase, the examiner finds that it lacks inventiveness and whether you would encourage the applicant to still nationalize it or not. So I think one thing that's important to note is that the findings of an examiner are non-binding. So it is still up to you as the applicant and whoever their patent attorney is to disagree with the examiner. It's not that their word is gospel and that you're not going to get rights. And there's also various bars of inventiveness in different countries. Some have a lower bar of inventiveness, others have a higher bar of inventiveness to overcome. So it's still up to the applicant to determine whether they think the examiner is incorrect and they're going to try their luck in other countries, or if you have an inclination that the examiner has a fair argument, it's unlikely. It's very subjective. So you would have to make that assessment at that stage. Okay.
Would the examiners say just public coverage is not inventable? Or would they say according to the United States patent laws it's not inventive, but it is inventive according to the UK rules?
No, so the question is whether if it's an international application, whether it's applicable to a specific country. So there's specific guidelines that WIPO uses and that you have to fulfill. And it also depends on the country that you elect to do the examination for you in the international phase. But they won't apply different countries' laws. They use a standard approach. Okay. And that's one problem, though, is that you might have one examiner with an opinion in international phase, but then when you file that application in America, they apply something a bit different because they have case law. They have different laws. So it's still variable, but it does give you a much better picture in the international phase as to whether there is validity in the invention. Okay.
Yes.
Okay, so if
So
we move on, yes, question
before we
online.
do, I just want to understand the difference between the Madrid and the PCT system. I just want to understand simply the difference between to designate, as you would do in the Madrid system, and to nationalize in the PCT system.
So look, to be honest, I'm not that familiar with the intricacies of the Madrid system, but how it works is when you file the application, you select and you pay certain amount of official fees to the regulatory body of Madrid, where you want those rights to be granted. So you make that assessment up front. Trademark people, am I right? Okay.
Yes, that
So you
is
make
right.
that-
Except
Yes.
except that, to my understanding, when you designate, the application would still go through the local trademarks office, so treat it as an application, and then issue a certificate of grant.
Okay. Yeah. As far as I understand, the grant of those rights are more simplified during the Madrid Protocol, where, yeah, to be honest with you, I'll need to think on that one.
Marco,
Because-
can I just interject? Sorry, can I
Yes,
just
go for it.
interject? So it's Razia here. I'm in trademark
Thanks,
prosecution.
Razia.
And just to give you an understanding, I hear where my colleague is coming from. So how Madrid works is, yes, you would designate the states, the member states that your client wants to file in to secure rights in. And generally in Europe and in America, it would go through very quickly, where your client would get a certificate. But unfortunately, it doesn't work that way in Africa. So what is the process is that the mark is supposed to be examined by the local authorities and not by WIPO. And they have a specific time frame within which to do that. They've got 15 months. And if they don't make the 15 months, then I think they get an additional 3 months. I stand to be corrected on that. But the time frame is very narrow. So if you don't meet those requirements, then WIPO automatically accepts the mark. So if your client looks on the Madrid monitor, it would appear that the local authority has accepted and registered the mark. But in actual fact, it's not the case when you look at the local registry. So there's the difference. I think the difference would lie in the fact that WIPO examines the mark and you have an understanding as to how the national authorities would view it. Whereas in the Madrid, it's not Madrid Protocol for trademarks. That's not what happens. I hope that clarifies the position.
Thank you so much, Razia. You saved me there quite a lot before I embarrassed myself further. Okay, so I hope that answers the question then. So as I understand it, there's then an automatic grant or an acceptance of the mark if it is not examined locally.
Yes, thank you. I don't mean
Okay.
to belabor the point. I hope at some point we will get to the breaking down of the process to nationalize through
No,
the
we'll
PCT
look at
system.
the PCT step by step.
Yes. Okay, thank you.
But with PCT, it's not an automatic acceptance of the application or grants of the application. It's still very much within the national laws to process the application nationally. Okay, sorry, just to go back. Some other treaties that we should consider is the European Patent Organization, where you can file a European patent application, designates in the countries in Europe where you want to obtain protection. So that would be, I guess, more similar to Madrid. Then we have ARIPO and OAPI, which are two African patent systems or intellectual property treaties. South Africa is not a member of any of those. Okay. South Africa wanted to maintain their autonomy, and with a lot of those countries, especially with OAPI, they had to give up their national IP laws in order to ratify OAPI, and South Africa did not want to do that. So if we have a look at the map here, the countries in red are OAPI patent countries. The countries in black are those for ARIPO. So the way that OAPI works, OAPI is a true unitary patent filing system. So you file one ORP application. Once it is granted, those rights are effective in all ORP member states. If the patent is invalidated in any of the ORP countries, it is invalidated across all the member states. Okay. And you can see the interesting thing where you look at the allocation of the repo countries and the ORP countries in red is that the countries in red were all previously French-speaking colonized countries. And then we look further down, it's more the British colonized countries that form part of repo. So where there are similarities in their law, those countries have pretty much joined together to have regional filing systems in Africa. But as I said, the two economic powerhouses of the continent are not party to either of those, so being South Africa and also Nigeria is not party to any of those. Okay, so yeah, I think this is a slide that a lot of people have been waiting for, is the PCT timeline. Again, we are going to touch more on the procedural aspects in a separate chapter, specifically focusing on PCT as well. But this is just to give you a quick overview and summary of what happens. So you have an inventor that has developed an invention that they wish to protect. They then file an international application. They don't necessarily need to file an international application in first instance. They can file a local application, so that you can file the application in South Africa, that you want the South African rights and not going the national phase route. So you can file the South African application. But in terms of Paris Convention, you can claim priority from that because PCT is considered a Paris Convention contracting state. Okay, so you'll file your application in South Africa. Within 12 months, you need to file your PCT international application. Okay, or you can file a PCT application in the first instance without claiming any priority. In most instances, countries will file a PCT application, or applicants will file a PCT application that claims priority from an earlier filed application. Okay, so they already want to get some indication from their own countries what their examiners might find. But that is then possible to go that route. So you'll file the application with the receiving office, which is then transmitted to the International Bureau of WIPO to process the application further. You also elect which searching authority you want to examine the application. So you can select the European Patent Office, you can select the Belgian Patent Office, you can select the Australian Patent Office to examine the application for you. So you'll do that in the application process. They will then carry out their search and they will issue you with your written opinion. Okay, so the examiner, once they've searched the application, they'll check for novelty, they'll check for inventiveness, and they will issue the applicant with the written opinion, which sets out their opinion, what their findings are. They will also list any documents that they may have come across which they believe invalidates or the invention. Okay, so where there is a prior publication of a patent document or journal article that discloses the invention, and they will provide you with those details. All of this, yes.
This is, for example, I guess it's like understanding of
Examine, yeah.
But let's say the JPO, what is the advantage here? Do they not examine worldwide in the
So the question is, what is the benefit of examination of the international phase? The benefit is the cost benefits to the applicants and also having a clearer indication as to whether the invention is actually patentable. So they can know before expending money by filing in Japan or filing in China and filing in South Africa directly, where each of those applications will be examined. For each of those examinations, you need to pay examination costs. Right. Yeah.
If I file in Japan, could they not do an examination that will give me a worldwide view of what the application invention is globally?
They will, but it also depends on the timelines. So you might not have that opinion in time in order to protect the rights in other countries. With PCT, you've got 31 months from the priority application within which to nationalize. So there is the benefit of having the opinion soon enough in order to still maintain, so you're still preserving your right to file national applications. Whereas in some countries, national searches can take several months. You can request delays of examination. There might be backlogs in specific countries. So I think that should answer the question then. Okay. Okay, so then the international application is ordinarily published within 18 months of the application being filed with the Patent Office that receives the application. So at that point, the application, whatever contents was disclosed in that specification, when it is published by WIPO on Patent Scope, that is public knowledge. Okay. So you can't retract, and that's where you might lose novelty if you don't nationalize. So that is already published at 18 months. If there are findings by the examiner that the invention lacks novelty, it lacks inventiveness, you as the applicant are entitled to amend it and continue the application through and to nationalize, or you can submit arguments and other claims that you want to examine again. So if you're providing a new amended claim set, you can request a demand, which is basically an examination on the amendments that you have made. And the examiner will examine the amended claims, and they will again issue you with a report, which is your international preliminary report on patentability. This is purely optional, okay? So it's this step over here. So hopefully then you know that you have overcome any issues that the examiner may have found. And that is basically then the international phase, what happens. Then you have either 30 years.
Can you have multiple amendments in international ways?
You can do multiple amendments, but you also got to keep in mind the timeline that you need to meet in order to nationalize that application. So this does take time. I mean, you're dealing with cutting edge technology. It requires a lot of mental examination. Somebody has to apply themselves and be very aware of their technology. So there's only a handful of people that can actually examine the applications. So you fall back into the queue to have it examined. All right, so you can, if there's enough time permitting, and you could probably request an expedited examination. I'm not too sure, but there is the likelihood of that. Okay. Okay, then the applicant has 30 or 31 months within which to nationalize the application. The 30 or 31 months depends on the country's own national laws. South Africa is a 31-month deadline country. And that is 30 or 31 months from the earliest priority date. So if you're claiming priority, you have to calculate that date from the priority date. If there's no priority application, that will be from the filing date of the PCT application. That's the first filed application in respect of that invention. Got a question?
Yeah.
Say the 34.
Yeah, so the question is whether there's any extensions for this in South Africa. So there is a 3-month extension that you can request to 34 months, but we'll have a look at that a bit later on again. And then online, was there a question?
Yes, I'm struggling to follow the priority point. Would it be an application which was filed someplace else, and it's a contracting state, and then you claiming priority from the date on which that application was filed? We start calculating from that date, the 31 months. I'm not entirely following.
That's exactly correct. That's exactly correct. So you understood it. Yeah. So the dates always run from the first application in respect of that invention. That will be your priority application, because that's the first application that you filed in respect of the invention in one of the contracting states. And if you don't have any of those, and you're filing a PCT in the first instance, then the date is calculated from the PCT filing date. Okay, but we will take a closer look at the PCT again. So Luke is asking, so you'll have 18 months from the PCT in the first instance. No, so if it's a PCT in the first instance, that is calculated from 30 to 31 months. That's 18 months if you're claiming priority. Okay, I hope that helps, Luke. Question? Okay, so the question is, what do I mean by claiming priority? So remember that you can file, in terms of the Paris Convention, you can file an application in one of the contracting states of the Paris Convention. So if I am Japanese inventor, I can file my application in Japan. In terms of Paris Convention, I have 12 months within which to file other applications that claim priority from the first filed Japanese application. The reason why that is permitted, well, not the reason, sorry, I lost my train of thought then. You need to consider at what point is novelty and inventiveness assessed. Okay, it is anything before the application filing date is considered to be part of the state of the art, which means that it is technology that is disclosed to the public, is available at that date. Okay, so anything before that date is considered. So what claiming priority does is it gives you 12 months to get your ducks in a row, to get funding, as an example, to obtain protection elsewhere as well, without losing that filing date of the first filed application. So if any disclosure is made after that first filed application, it is not considered to be novelty destroying. It is not considered to be lacking inventiveness at that point. Does that help? Okay.
Sorry, before we move on.
Yes.
According to the Paris Convention, as you say, you have 12 months to file
Yeah.
elsewhere. And I'm trying to reconcile that with the 31 months in terms of the PCT. If you're claiming priority, you claim it within 12 months. But
Yeah.
the PCT says you can file, sorry, you can nationalize after 31 months. Am I
That's correct.
missing something within these deadlines? Does the PCT override the 12 months?
It does, yeah. So PCT or WIPO is considered a Paris Convention state. So you can file a PCT application within 12 months from claiming priority. But then you move over to a different treaty. Now it's in the realms of PCT. And remember, these are only countries that have agreed to this. So their laws permit you to do this. You are then, in terms of PCT, required to nationalize within 30 or 31 months.
Oh,
So
okay.
you relied on Paris Convention to claim priority to file the PCT.
Oh, okay.
Once you filed PCT, member countries that belong to PCT then permit you to nationalize within 30 or 31 months.
Yeah. So if for example you filed an application and then claimed priority within 12 months you filed your PCT. I'm trying to understand that priority takes you back to when you first filed in that contracting state.
That's correct.
And that takes you to the PCT. And then I'm trying to see when you have got to do your nationalization within 31 months, you start calculating from the priority date and not the date on which you filed your PCT.
That's correct. Yeah.
Okay. All right.
That's exactly correct. Okay. Thank you. Just as an example, so let's consider a country, Taiwan. Okay. Whether Taiwan is their own sovereign state or not is debatable, matter of opinion. But Taiwan is not a PCT member. But Taiwan is a Paris Convention member, right? So you can file a Taiwanese application in terms of Paris Convention, claim priority within 12 months. But now you're filing a PCT from a Taiwanese application that you're claiming priority from. That's an invalid priority claim because Taiwan is not a member of the PCT. So it's an invalid application. Okay. So I think that also hopefully clears up some of the issues, that it's also, you have to be a member in order to benefit from these timelines. Another question.
Simplify the priority date myself a bit. I believe it's your first application ever as the owner in that instance. That's your priority date. And then every application going after that, it's almost as if you backdate it.
Yeah.
That's your priority date. So it's as if you filed your priority date is the 31st of December and you file another application in January or March. It's as if you filed in December.
Yeah. That's in terms of novelty and inventiveness, that's the case. Yeah. So the suggestion that the lady made is that it's almost as if the application's backdated to the priority date, which in terms of novelty and inventiveness is. Okay. Okay, another question.
Just your example, invalid priority date application. If you then try to do a PCT application, would you have lost your novelty?
If it was disclosed. So if the Taiwanese application became a public document, then you would have lost your novelty.
But before that,
if before that it's still fine. Yeah. As long as it's a secret document still, it's fine. Okay. Okay. A lot of questions on this one. Yes, at the back there. Because that's what the courts would look at to determine whether that invention is new and novel. So it was, from what point did that invention come into existence? And that would be the filing date, is when you first sought application to protect it. Okay. Okay, that brings us then to the end of international arrangements. Don't worry too much with PCT and the timelines. I know it's very confusing. We will go through it again, better detail, and hopefully it will clarify a few things. Okay, we're moving on then to patentability, which, as I mentioned, is probably one of the most important sections for this workshop and for examination purposes. So what are the basic requirements of obtaining a patent? What requirements must be met in order for you to be granted a patent? And this is set out quite clearly in terms of section 25(1) of the Patents Act. It says that it must be an invention per se, by its definition. There is a definition in the Patents Act, but it doesn't really provide us with anything, okay? It just says an invention is an invention in terms of, for purposes of the Patents Act. It doesn't tell you what an invention really is in the Patents Act. But the Act does tell us what is not considered an invention. So there are exclusions from creations, things that exist that are excluded from being patented. And we'll look at those as we move on. The other requirement is that the invention must be new. Okay, we've discussed novelty and it being new. These are synonyms and we use them interchangeably. So the invention must not have existed at the time which you are making the application for the invention. Okay, so it must be new. And remember, we said it doesn't need to be a groundbreakingly new invention. It just needs to have a novel feature that is considered new. So let's consider the cup or this flask. Okay. It's got a flask, right? This is, imagine this is a new flask. It's the first flask you've ever seen. Double walled, keeps the water cold, keeps the contents hot, depending on what temperature you want it to be. Right? So it's vacuum double walled flask. This is the product that I'm protecting. Okay. It's a container or a receptacle for holding liquid. That's my patent claim. Okay, very straightforward hypothetical example. So this is new. This has never existed. Okay, I file an application for this. But now I'm traveling and the car's going around and my contents is spilling out exactly like that. So what do I want to do? I want to prevent it. I want to make an improvement on this product which has already been patented, which already exists. So I come up with a screw cap, right? I'm solving a different problem. My first problem was I need something to hold my beverage. My second one is I need something to prevent it from spilling out, okay? So somebody might have the patent on just the receptacle, the flask. But somebody may have thought, well, I can improve on that technology. I can put the screw cap, right? So now I have a receptacle for containing liquids and a threaded screw cap to prevent the contents from spilling out. Okay, based on the flask, but it's a new invention altogether.
Yes, sorry.
Okay, so this is an improvement on the existing technology. So if the courts had to determine whether this invention with a cap is new, it would be considered new because it was never disclosed to have a cap. And that is where the skill of a patent attorney comes in, because they need to draft claims in order to give the applicants the broadest scope of protection. So when you're drafting your patent claims, which is what defines what the invention is, what defines the monopoly, it's what the courts look at when determining, is there an infringement on that patent? They look to the claims, okay? So if my claims are very narrow, where I specify, let's just look at this as the example, that my receptacle, I have a receptacle for holding liquid. That's the claim. But now if I say I have a receptacle that is made of aluminium, I'm limiting the scope of my protection. Okay. Because my invention is specific to an aluminium flask. What if somebody comes along and decides to make a glass flask? Are they infringing? They're not. That's not what my claim specified. So you need to write your claims as broadly as possible in terms of what is permitted and what's known in the prior art in order to cover the client's basis, all right, to give them the broadest scope of protection. So if there was no material that was previously used for these flasks, I'm not going to define what the material is. I'm just going to say a receptacle capable of receiving a liquid. Everyone with me? Okay. Or I can say a metal as opposed to specifying which metal. Okay, so got to think broadly to protect everyone. Then we've got the script. Then we might have a sipping nozzle. That's also a new integer. Okay, that may not have existed. Okay, so those are all improvements on the technology. And these are all capable of being protected. You only need one feature of an invention to not have existed in order to protect it. Whether it is inventive is a different story, but that's a different test that's applied. And that is then brings us to the next requirement. Yes.
So an aluminium part would then destroy wood.
Yes. Yeah. Yes.
Let's say you're saying it keeps water cold between 20 and 10.
Yeah.
Right? And then someone comes and say in the part it keeps water cold between 10 and 25.
Yeah.
Does it destroy?
So if the range is, if it falls within the range, then it would. But if it's outside the range, then it's okay. Yeah. Yeah.
So that kills it.
Yeah. Okay. Okay, so then the next requirement, as I said, is that the invention must be inventive. Okay. The step in terms of the act, what is the inventive step is that the invention must not be obvious to a person skilled in the art. Okay, so if I'm a manufacturer of flasks, this is my expertise, the field of technology that I work in. If I didn't think it obvious to put a cap on, then it is inventive. But if it was something that was obvious, then it would not have inventiveness. Can you see the distinction between novelty and inventiveness? The one is objective, the other is subjective. With novelty, it either exists or it doesn't exist. That feature exists in the prior art. It was known to man, but wasn't known to man. Okay, it's black and white. Either that integer is there or it's not. With inventiveness, it's subjective because now you are relying on a person skilled in the art, whether it is obvious or not. You're bringing an element of subjectivity to that. So when the courts need to assess inventiveness, the parties will bring in expert witnesses to give an opinion to the court as to whether they deem it to be inventive or not. Okay, the court's not bound by that opinion, it's merely an opinion, but the court needs to place themselves in a position to make that assessment and relying on an expert witness's opinion. Okay, just the gentleman there first.
So, like a definitive way to see if it's inventive or not.
Yeah.
Because surely if it's not in the prior art, it wouldn't be obvious to someone skilled in the art, because then they wouldn't paint it already.
Not necessarily. Somebody might just not have had the impetus to actually do it, or you know, it's difficult to say that. It's, you know, would it have hit you like a flash? You know, oh, that was obvious. I should have thought of that, or not. So it's, I don't think that's entirely correct that it should have existed. Okay. Then next question, yeah. Yeah.
If let's say I come up with Coca-Cola recipe is not public knowledge. So it's patentable. I don't know that is the same formula.
So the question is if there is the Coca-Cola recipe, which is, we all know it's a trade secret, and I'm able to formulate that same recipe, get the same results, and I want to protect that. Can you do that? No. The reason being is that the Patents Act expressly states that anything that is used secretly and on a commercial scale is not capable of patent protection. So it destroys your novelty. So if it's used commercially and in the borders of South Africa. So maybe if Coca-Cola wasn't in South Africa, you could, but it is. So anything that's yeah. Okay. All right, then the last requirement in terms of section 25(1) is that the invention must be capable of being used or applied in trade or industry or agriculture. Yes.
What will then happen if you take that? Will they come after you?
So the question is whether you're talking about the secrets, the trade secret. So if the trade secret is used in South Africa, although it's not, the product itself is not utilized in South Africa. I mean, they could probably have other forms of recourse that, you know, maybe it's anti-competitive or there's unfair practices at play because they did develop it. But I don't know where it would go. In terms of IP protection, you're not protected. Yeah. Okay, so the invention must be capable of being used or applied in trade or industry or agriculture. So there must be utility for this product. You know, there must be some use for it. I've never come across an invention where it wasn't found to be useful in any way. Okay, so if we look at inventions more specifically, so in order for an invention to be patentable, it must meet certain intrinsic and extrinsic requirements. And then again, these most importantly are found in section 25(1). So section 25(1) is what we just went through, but if we're looking at the exact wording from the Patents Act, it says a patent may be granted for any new invention which involves an inventive step and which is capable of being applied in trade or industry or agriculture. So the intrinsic requirements, so by very virtue of its nature, is the invention patentable per se in terms of section 25(2), which defines what is not an invention. Anything that doesn't form part of section 25(2) and the other provisions in the Act where there are exclusions from patentability is capable of being protected by a patent and is considered an invention. So very importantly, section 25(2) provides us with a list of exclusions from what is not considered an invention. Okay, the first being discovery, then a scientific theory, mathematical method, a literary, dramatic, musical or artistic work or any other aesthetic creation, a scheme, rule or method for performing a mental act, playing a game or doing business, program for a computer, or the presentation of information shall not be an invention for the purposes of this Act. So anything that falls within those exclusions is not patentable. Okay, why? So if we think about a discovery, exactly. A discovery is something that has already existed in the natural world. You are not creating. You have just discovered something that has existed. You might take that thing that has existed in the natural world and you might enhance it. You might process it so that it's safe for consumption. So if you think about a plant, Okay, there's a specific compound, phytochemical, that a plant produces. If you are able to process that phytochemical, make it safe for ingestion, that it doesn't kill you or have other side effects, that is likely patentable. The compound itself that you found in that plant won't. It's existed. But the way that you've processed it, the way that you've made it safe for consumption, that didn't exist. Okay, so you can take a discovery, improve on it in order for it to be patentable. Okay, so something that's already naturally existed in the world, you can't patent. The scientific theory. So scientific theory is merely a manner in which to explain a certain aspect of the natural world. Okay, so if you think about Newton's laws of gravity, the rules of thermodynamics, these are all things that exist naturally, but the scientific theories are what explain how the natural order of the world works. So unpatentable. And then similarly with mathematical methods. Again, it's just a description of a system using mathematical concepts to define something that exists naturally. So the theorem of Pythagoras as an example, okay, in order to calculate the side of the triangle. Then a literary, dramatic, musical, artistic work or any other aesthetic creation, that should ring a bell. Copyrights, okay? There's separate legislation that protects these artistic works, literary works, creations, or the 9 works defined in the Copyright Act. What about aesthetic creation? Okay, designs as well. There's sui generis law that will protect aesthetic creations. So that is why those are excluded from patentability. Then when we look at a scheme, a rule, or method for performing a mental act, playing a game, or doing business, these are considered essentially mental steps or methods of applying one's mind. So again, not really creating anything, but a way in which you apply your mind. What about a computer program? Again, copyright. This is protected under copyrights, okay? And then lastly, the presentation of information, which also falls within the ambit of copyrights. Okay, it's the way that you're presenting information on a graph, on a poster, that will then be within the ambit of copyrights. Okay, so this slide, we've basically worked through it's each one of the exclusions that we've touched on, which you can go through. Importantly, section 25.3 does have a caveat. It tells us how we should interpret section 25.2. To what extent are those exclusions applicable? And it tells us in section 25.3 that it is only to the extent to which a patent or an application for a patent relates to that thing as such. Anything from being treated as an invention for the purposes of this act. So section 25.3 tells us that those exclusions must be interpreted narrowly, okay, because it's only as it applies as that thing as such. So think about a computer program, okay? The code is protected under copyrights. But what about the way that it makes my cell phone operate? How does it integrate with the hardware? How does it solve the problem? How do I have a touch screen? It is all driven by code, but with the interplay as a system, there is a computer program. But surely this should be patentable, okay? Because I'm not just protecting the code, protecting the system of how this functions. So how does it interact with the hardware, the software and the hardware? So if I touch the screen, it lights up. Okay. There's no case law on this in South Africa on how section 25.2 should be interpreted. There is case law on it in Europe, specifically relating to computer programs. So where there is a technical effect, as you can see on the presentation here. So where it solves some problem, the software solves some problem with an interplay altogether in a system, and there is a technical effect that solves a problem, then it is likely to be patentable. Okay, but just that code, the ones and the zeros, that is not patentable. But how it integrates into a system, that is likely to be patentable in South Africa. Okay, what about some other unpatentable inventions? So we've had a look at section 25.2. There are further exclusions from patentability in the Patents Act. We look at section 25.4. It says that a patent shall not be granted for an invention, the publication or exploitation of which would generally be expected to encourage offensive or immoral behavior. Okay, so any invention which would encourage offensive or immoral behavior. Again, where's the line? Who knows what is immoral? Who knows what is offensive? We all have different opinions, we all have different views. So that's quite a shifting boundary. Some examples that we might consider where a compound is used as a date rape drug. Surely that is immoral, just an example to consider. What about stem cell related inventions? Might be, might not be for some, okay? Depending on where you're obtaining it from, the stem cells. All right. Then the next exclusions. For any variety of animal or plants or any essentially biological process for the production of animals or plants, not being a microbiological process or the product of such a process. Okay, so quite a mouthful. So any variety of animal or plant. So let's think about animals. If I'm creating a new variety of animals, so let's think I cross my Ridgeback with a Jack Russell, and this is actually my dog. It's a Ridgeback Jack Russell cross. It's a very weird combination. Can I protect this new breed of dog in terms of the Patents Act? No, it's a new variety, okay, of an animal. I can't protect a new breed of a dog. What about a plant? Okay, let's think about going to the supermarket. You see those delicious cotton candy grapes. They're incredibly sweet. They're seedless. They've got that nice crunch when you bite into them. That grape probably didn't exist naturally. All right. It's been genetically modified. It's been crossbred, whatever technique they used to enhance specific characteristics that we want, that we find pleasurable as humans. Is that patent protected? No. It's expressly excluded from the Patents Act. But we have the Plant Breeders' Rights Act. So that was the discussion we had earlier. We've got the Plant Breeders' Rights Act, which will protect the variety of the plant. So similar with copyright, we've got literary artistic works that are excluded. Yeah, plants are excluded because there's sui generis legislation that protects plant varieties. But then it tells us, okay, so you can't protect those in terms of patents, they're not inventions. In terms of the Patents Act. If it's not, let me rephrase, not being a microbiological process or the product of such process. Okay, where do antibiotics come from? Microorganisms, okay? They're cultured, grown in the lab. That is a microbiological process. That is patentable, okay? So if it's a microbiological process, or the product of that microbiological process, you're able to protect that. It is considered an invention in terms of the Patents Act. Okay, does These are important provisions that you need to know. Yes.
I heard just understanding that this section is not doing for example.
How do we examine it? Okay, so the question is how do you answer a question when this is bad? The thing with patent law is that it's very specific, and a change in word renders it either useless or provides it with a different meaning or different interpretation. So if we look at section 25(4)(a), or no, let's rather look at B. So any variety of animal or plant, those are two separate items. So you have to specify that it is relevant to plants and to animals, because you'd likely lose out marks. And there's so much held in these provisions that the words are so important. Obviously, if you get the crux right, but if you do leave out something that is of importance, where you're only saying, well, it's only applicable to animals, well, that's not true. It's also applicable to plants. You'd have to mention both of those in examination purposes, for examination purposes. If you tell me it's not a microbiological process, if I make sense of what you're saying, that's okay. So the words don't need to be exactly specific, but the interpretation and the meaning needs to be there. Okay. So that's why it's very dangerous to move away from the words that are provided in the Act. Okay. I know it's difficult because it's almost like you're studying as a parrot, but there's very specific meaning to each of these words. Okay. Right, another question at the back. Yeah, that should be fine. Yeah. I mean, I try to be lenient in the marking. If it doesn't make any sense or there are things missing, you're not going to get your full marks. So the mark allocation will likely be for animal and plant. So if you omit one, you're not going to lose all your marks, but you might be penalized on some of it. Okay. Okay, then if we move on, section 36 provides the registrar of patents with a discretion to accept or refuse certain application. So unlike with the other exclusions we've seen, those are clear-cut, they are not permitted. With section 36, the registrar has a discretion because of the word may. So the registrar of patents may refuse. It doesn't say that they must refuse. So the registrar of patents may refuse inventions which are contrary to well-established natural laws. Okay, so this would be, for example, that we have on the slides is a perpetual motion machine. So you can't have a perpetual generation of energy without a source of energy being input to it. So you can't just have an output of energy being created perpetually, right? That's against the laws of nature. So the patent, if the registrar of patents comes across an invention like that, they have the discretion to allow it or refuse it. If they allow it, whether it's enforceable is a different story. Then it's up to a third party to challenge its enforceability or not. Then again, an invention which would be generally expected to encourage offensive or immoral behavior. So this reads exactly onto section 25(4)(a), which we saw earlier. There it says that it shall not be granted, but in section 36, it's contradictory, it's saying that the registrar may refuse it, they may not refuse it. I don't know, honestly, why there is this distinction between the two in these sections. I guess it could possibly be that because South Africa is non-examining, that the registrar may not pick up that an invention would possibly encourage offensive or immoral behavior. So if it is allowed, then there is the fallback provision that it should not be granted, and there could be recourse in that instance. Yes.
So the registrar finds.
So it wouldn't be possible to appeal it, but it would be possible to revoke the patent. So you would need to approach the court and ask the court to revoke the patent based on this ground, because this is one of the grounds in terms of the revocation provisions in the Act that you can revoke a patent on. Okay.
Sorry, may I please interpose?
Yes, there's a question.
Yes. I'm just worried about the provision in section 36, which says inventions which are contrary to well-established natural laws. It seems it places a curb on or a limitation to inventions. For example, if someone were to come up with, for example, there has been an invention already on cars that operate on water. And obviously, the concern derives from the commercial element of it. It is preferable to the oil industry for the continued reliance on petrol, for example.
Yeah.
And there is endless supply of water. And if that invention were to take precedence in this day and age, it would eliminate or render them obsolete. Is this not where we are here? Am I taking it too far?
I think it's maybe taken a little bit too far, to be honest, because I don't think that is something that falls within the natural laws. But I do get the point that you're making. And the way that that would be addressed is that the courts would often have to weigh up the public benefits and public interest against whoever's arguing against that. So it would come down to the courts to consider, is it in public interest or not? But I don't think it falls within the ambit of natural laws. That invention of using water is new, even though water is natural. But the use of it in driving the motor vehicle as being combustible in some way, that doesn't seem to fall within the provisions of Section 36.
Okay, thank you.
Is everyone still awake? I can see you getting a bit tired here. All right. Okay, we've got a few more questions. Okay.
Sorry, I'm actually coming up. Subsection 11, where it says the method of treatment.
Yeah, we're getting there. I jumped the gun. Okay, method of treatment. There we go. Okay. All right, so yes, another question. Anything that defies? No, there's no case law on it. Sorry, I think I missed a part of the question. No.
Could you define something that's natural? Sorry. Could you define something that's natural? Yeah, for example, you said so if someone does what but for me that's impossible. But if they do, then I guess that's why there's discretion of the registrar. So the question for the online members is that what if somebody is able to overcome the natural laws and they do come up with a perpetual motion machine? What would happen? Well, that's where the registrar has the discretion to allow it. So they would have to consider it. And they can probably call the applicant to put arguments forward as to why and show me before they actually accept it. So there is a discretion. It's not an outright refusal. Okay, so that's where you must make that distinction in section 36. It says the registrar may refuse. It doesn't say they must refuse. So there is a discretion on the registrar to allow that application. Yeah. Then I saw we had a question online before we move forward as well. So then Ratzia asked, what about cancer treatments? Can you patent it? I'm thinking of isotopes. So yes, I mean, it would be safe. The isotopes as such existed naturally, then no. But if you are making it safe for human treatment, the processing of it, the extraction of the treatment that you're using, then there is some patentability and novel integers that you could protect. And I mean, that's the case with most, well, I can't say most, but majority of pharmaceuticals are derived from some plant, especially in South Africa. South Africa is so rich in its diversity when it comes to plants and the medicinal properties and phytochemicals, that there is a lot derived from plants for medical purposes. Okay, then let's move on to, I'm just trying to find my slides here.
We're on 2511.
Thank you. So section 2511, a very important provision in the Patents Act. As well, I can guarantee you there's going to be something based on section 2511. Again, another exclusion from patentability in the Patents Act. Section 2511 provides that an invention of a method of treatment, the human or animal body, by surgery or therapy or of diagnosis, practice on the human or animal body shall be deemed not capable of being used or applied in trade or industry or agriculture. Okay, so should we go through it again? A method of treatment of the human or animal, so we're looking at humans and we're looking at animals, by surgery or therapy or of diagnosis, practice on the human or animal body shall be deemed not to be capable of being used or applied in trade or industry or agriculture. Does that make sense? No, it does. Why is this provision provided for in the Patents Act? Why can't I protect a method of performing a surgery? Exactly. So the answer is that doctors would be infringing such rights. I mean, it's against public interest if there is a life-saving medical technique or surgery to prevent a patient from passing on that could save their life. But now, what? The patient's on the operating table and then they're going to get slapped with an infringement suit. That doesn't seem right. That is probably immoral. All right. It falls against the mandates that a doctor has, against their oath to save lives. You can't prevent them from performing life-saving techniques. Similarly with animals, because this doesn't just apply to humans, so it's very much applicable to veterinarians as well. Okay, because it's on animal or human bodies. So you cannot patent a method of a surgery or therapy or diagnosis. So I can't patent the way in which I diagnose an illness. The item that I might use to diagnose is patentable, but the actual process of diagnosing it is not patentable. Okay. So if I have an X-ray machine, the X-ray machine is something that I've developed that is patentable. But the way in which a patient needs to lie in order for me to take that X-ray, in order to diagnose a patient, is not patentable. Okay. So the device, the tool, that product of the patent, of the invention, is likely to be patentable. Okay. But you can't prevent a medical or veterinarian, a practitioner, from performing surgeries or diagnosing a patient. Okay. Again, the words are very specific. Remember, it's not just humans, it's animals as well. It's not just surgery, it's diagnosis and therapy as well. Okay, so therapy. I need to take 2 Panados for my headache today. All right. That is the therapy, that's the prescription. You can't patent that. Why this becomes problematic, and I'm turning to the States again. In the US, this is permitted. Okay, so in the United States, a method of treatment, method of surgery, they can patent it. That is an invention in the US. But now remember, we're working in the global sphere. They've written their description of the invention in America, and they want to protect some inventive aspect of that application in South Africa. They filed that US application into South Africa, but I'm sitting with claims that are claiming a method of surgery or a method of treatment or a method of diagnosis. In terms of Section 2511, that's not permitted. Those claims are not valid in South Africa. So that's where the role of a practitioner in South Africa would come in, is to assess, and this is in a South African context because there's no examination yet. So what happens in practice is that the patent attorney will take on the role of an examiner. So they will have a look at that specification that was filed in South Africa and advise the client that your invention includes claims that are related to a method of treatment, which is not permitted in South African law. This is what you should consider doing in order to not have an invalid patent. So there might be something else that you can protect. So the compound that is being used, you could perhaps protect, or the tool that you are using to perform the surgery. Okay, so you would have to look at how those claims are reworded in order to obtain some protection in South Africa for the client. If there was some examination, the examiners, when they reviewed the specification upon examination, they would see that these are method of treatment claims, and they would object to those in their opinion to the applicants. All right. Yes.
Then what is the relevance of the international arrangements in such a case? Would we then say that, let's say, as a member of one of the international arrangements, and since it's permitted in their country for them to be able to file such a patent, would they then be able to override the Section 2511 provision?
Look, if that is silent in terms of the treaties, which it is, then their laws will prevail. The national laws always prevail over international laws. Okay. Okay, then I just want to jump to Section 25.9. Sorry for jumping on the slides, but this will make more sense now when we go back. So Section 25.9 of the Act provides that in the case of an invention consisting of a substance or composition for use in a method of treatment of the human or animal body by surgery or therapy or of diagnosis practiced on the human or animal body, the fact that the substance or composition forms part of the state of the art immediately before the priority date of the invention shall not prevent a patent being granted for the invention if the use of the substance or composition in any such method does not form part of the state of the art at that date. That is a mouthful, okay, but very relevant. What section 25(9) is telling us? It's telling us that if there is a compound that already exists, it is in the prior art, it is known to man, but there is a new use for that compound. So if it treats something different to what it is already known to treat, then that use of that compound for the new treatment is patentable. So even though that compound exists in nature, or not in nature, but that compound was already manufactured to treat something, but it is used for a different treatment, then it is patentable. Okay. So let's go back. So we know now, section 25(9) also tells us that compounds and compositions for use in medical methods of treatment are patentable, okay? So the method of surgery, not patentable, but what I'm using in treating that patient, the medicament, the compound is patentable, okay? So the method of slicing someone open, not patentable, but the product that I'm using on that patient is patentable. Okay.
Sorry, before you go too far, can I please take you back to 25(9)? I just need some clarification there. I didn't quite follow what it means.
Okay. So let's go. I am still getting to the crux of section 25(9), but let's have a look at it again. It says, in the case of an invention consisting of a substance or composition for use in a method of treatment. So where there is a compound or composition to treat a patient while I'm using it in the surgery, that is patentable. But section 25(9) goes on to say that the fact that that substance or composition is already known. So say that compound was already known. It was already part of the public domain. It is not considered novelty destroying if that compound is used for a new treatment. So let's go back to the slides where it will make a bit more sense. So let's say we have aspirin. Everyone familiar with aspirin, right? Aspirin was initially a chemical compound, right? It was used for completely different purposes as to what it's used for today. That was the use of that compound previously. It was known. Then it was discovered that the aspirin is able to provide pain relief when ingested. It is a different use of that compound that already exists. And we know from section 25(9) that that is patentable. Okay, so let's look at the example there. You've got salicylic acid, which is the active in the compound for use in the treatment of headaches. These are hypothetical, but that is basically what it's used for. So let's say that was the first use, was to treat headaches. But then over time, it was enhanced to treat something else. It's used as a blood thinner, okay? So to prevent your blood from thickening, to prevent strokes, prevent clotting. So a lot of people, when they travel on long-haul flights, they will take an aspirin to thin their blood so that they don't clot whilst they're traveling and to prevent a stroke. So there it is a different use. So the first use of the salicylic acid was for the treatment of headaches, right? That compound's known. It's the same compound. That compound is now being used for something else, to blood thin, all right? That is patentable, okay? So where there's a different use, that same compound's being used, you can still obtain a patent for a different use. So these are your first and second uses of a known compound. Okay, question. No, by compound, it's pharmaceutical compounds. Yeah. So I can't say this is not applicable to a broom to sweep the floors and a broom to dust cobwebs. No, it's purely for pharmaceutical compositions and compounds. Okay. Question?
So it says that it's applicable to both first and second medical use of a known compound or composition. But if in the first instance, first medical use, if that was already known, is that not novelty destroying?
But that's where section 25(9) comes in, where it says something that would have ordinarily been novelty destroying, where that novelty destroying compound, let's say that novelty destroying compound is then used for different use. That novelty is not destroyed.
Yes, but that's the second medical use. So
But first and second medical use are both permitted.
first medical use, at some point, it would still be though, let's say there wasn't second medical use yet,
Okay.
and we're just on first medical use.
Yeah.
If it's known, surely that's novelty destroying.
Well, the compound, but the function of that compound where it's being used is not known. So if that compound existed, it's about the use. So the focus is on the use of that compound. Okay. So the way it will be done, so say salicylic acid, that's the active ingredient, was first synthesized in the lab. That compound, say it didn't exist naturally, you would protect that composition. Okay. Then you'd say, okay, well, there's a good function to this composition. Then it would be the use of that compound for treating something. So for headaches. Then further on, there's another use, would be for blood thinning, as an example. Okay. What are some other examples that you can think of that might be well known of a compound or a tablet that was used for one thing and then was discovered to work for something else? I'm talking to the guys specifically. Don't be shy. Eh? Viagra. Viagra, yes, Viagra is one of those examples. Okay. Viagra was initially used to treat blood pressure, to regulate blood pressure. Then it was discovered, well, this works for erectile dysfunction. So, okay, different uses, same compound, but they're both patentable.
So just first, second medical use. Let's go back to the salicylic acid example. So it treats the headaches, because it's of its blood thinning ability.
Yeah.
So if salicylic acid, for some reason, in years' time, they find that it does something completely different. So it also affects your cognitive function, but not because of its blood thinning capabilities. Can you do a first medical use claim? There's a completely different function of the drug.
No, because the compound is what would destroy the novelty. So you're still using salicylic acid, right?
Yeah.
Yeah, but then it would still be a second medical use. Okay.
So it's just if it's being used in a medical field.
Yeah. Then it's protectable. Okay, I hope everyone's on the same page. Okay, because this is important. Yes. Okay, so that's what we're coming to now, is that the courts in this Elon Transdermal versus Ciba-Geigy case, they told us how those claims should be drafted, where it's a first medical use of a compound or it's a second medical use of that known compound. So in Elon Transdermal, they said that if it's a first medical use of a known compound, so salicylic acid for the treatment of headaches, needs to be claimed in the for use type claim format, okay, which is what is set out here. So it's compound X, so the salicylic acid, for use in the treatment of disease Y. So the disease being for treatment of headaches in a patient. So that is what your claim in the patent specification would look like. So if it's a first use of a compound, first medical use of a known compound, the court has sanctioned the for use type claim. So that is the format that you need to follow as a patent attorney when drafting a claim, that it must be in that format, the for use type claim. Why there's a distinction then with a second medical use doesn't personally really make sense to me, because it is sanctioned by section 25(9). But the courts have said, if it's a second medical use of a known compound, we have to use what is known as the Swiss type claim format, which is the use of compound X, so the salicylic acid, in the manufacture of a medicament to treat Z, a different disease. I don't see the purpose of this, but this is what the courts have told us to do. So we have to follow this in South Africa. In Europe, they used to follow this approach, but Europe has moved away from this approach. They're now using EPC 2000 claims, and have done away with Swiss type claims. So even if it's a first or second medical use, in Europe, they follow the for use type claim form. They don't worry with the Swiss type claim form. But for South Africa, this is what the courts have sanctioned, and this is what we need to approach until the New Patents Act or regulations or guidelines or case law tells us otherwise. Okay, so this is the sanctioned claim formats. Does that answer you? It would be novel if it wasn't known that it was treating backaches prior to the first medical use. Okay. So even though it's a type of pain, if it's very specific, you'd have to look at the specificity of it and the way that the first use was actually claimed previously as well. So you'd have to see what the claims were for that specific use previously. Okay. Okay, multiple questions. Let's go in front here.
And same group of people mentioned that to realize that in that there's actually more than one of these that can find both of them or even more.
Yeah, it does.
So I separate by different
Applications. Yeah. And we'll get to that as well. Okay, another question? Just hang on, the lady was there first.
For example, for salicylic acid, I don't know if they're ingesting it with like a putting it on their head. For example, if like they were putting it on your head and that was like for the headache use. And then, but then you notice that your pimples are going away. I mean, which is still like, can a other party come and say, okay, like second use now, even though it was incidental to me, like putting it on my head.
Yeah. If it wasn't known to the proprietor of that first use, then it is possible to protect that second use. Even if it's, I mean, it's, and it happens. For instance, somebody once told me that they were using anti-dandruff shampoo because they had dandruff. So they're treating this, and same thing. they realized that their acne was decreasing. And why would that be? Dandruff is fungal infection. And you also might have acne, which could be caused due to a fungal infection. So different uses of the same compound, treating different issues, different symptoms. Yeah. Okay, another question, then we'll come to you next. Okay, let's let the Jane thing go.
Would you, for example, say this is now your American client, he has his claims of his American specification says the use of salicylic acid to treat this person or whatever. Then you would ask us to advise basically the client on how to make sure that it's patentable according to South African standards, and then we'll basically advise, okay, you need to amend your claim, which you'll also tell them practically how to go about that.
So that's one of the ways. So there's various ways in which this can be examined. The one would be a typical client sees you in your consulting rooms or your boardroom. This is what they've discovered from this known compound. They want to protect it. How would you advise them to protect it? Or this is the specification that they have filed. It's got this claim in it. In terms of South African, is that claim valid? How would you advise them to protect it? Other example might be, how did the courts sanction us to protect these types of inventions? What claim format should you follow? But it won't be that complicated. There might be a lot of words, but at the crux of it, it's not. So just don't get overwhelmed by this type of question in the exam.
You know, when they might say this was used previously for this, but now we have discovered it can be used for X amount.
Yeah.
Then you'd advise the client, okay, let's amend your specification, or we're going to draft your specification to claim it in a second.
Yeah. So in that instance, you should touch on section 25.9 to say that section 25.9 does provide that a use, a different use of a known compound is patentable. So, you know, what would you tell your client? You would tell them, well, this is what the law says, so that's what we should do. Yeah. So always try and reference what the law says, okay, when you're answering any questions in the exam. Right. Okay, another one.
So the change in wording, does it change the scope of protection, or is it just so the courts are happy?
This is mostly to satisfy the courts at this point in time, because because of section 25.9, I don't believe that this is relevant, the Swiss type claim format, because it is sanctioned that you can have a use of a compound, a known compound, for the treatment of a disease. Whether it's first or second shouldn't matter. So this is purely to satisfy the court's requirements. But if you look at the way that these claims are drafted, in first medical use, it's a compound X for use in the treatment of disease Y. So it looks like it's more focused on the compound, which in that also doesn't necessarily make sense. Because you're not really claiming the compound, you're claiming what it's treating, the use of that compound. Whereas the Swiss type claim, it specifically has to say in the manufacture of a medicament, so a medication. So you are protecting that manufacturing process of the medicaments, but it's not necessarily that you're protecting that's what you want to protect. You want to protect the new use of that compound. But this is what we stuck with. Okay, so this is what the courts have sanctioned. Okay, everyone happy? Yes.
So generic medication is not exactly you can't exactly have a patent on it because the compounds already exist fine and the treatment is the same, it's just the difference company.
Yeah. So the question of a generic pharmaceutical is basically the same compound for the same treatment that is manufactured either by the same company or at a lower cost, or a generic pharmaceutical company where the patent has expired. Okay, so the patent has, so if you think of Miprodol and Genpain, Genpain is the generic of Miprodol. So Miprodol was the originator pharmaceutical company, or the tablet, the Miprodol tablet was the originator for its treatment, whereas Genpain is the generic of that product. Okay. So once the Miprodol patent expired, then whoever manufactures Genpain was permitted to do so because there's no patent on it. Okay. With generic pharmaceuticals, they still have to go through the same regulatory hurdles as the originator. So same medical submissions need to be submitted, has to undergo medical trials, that data needs to be submitted to the regulator in order for it to enter the market. They can't just put it on the market. Okay, they need to submit stuff, and we'll get to that a little bit later on as well. Okay. Yes.
Then section 2512 of the Act. Because section you mentioned earlier, that not only second medical use, 25.
Yeah, you're right. You're right. This, sorry, I don't have section 2512 up here. Let me just quickly have a look at section 12. But it goes along the same lines as well, that it permits it. Yeah, so section 2512 says that subsection 11 shall not prevent a product consisting of a substance or composition being deemed to be capable of being used or applied in trade or industry or agriculture because it is invented for use. So this is just providing that a for-use claim is permitted.
Sorry.
Yes, there's another question online.
Yes. Just on the previous slide, that yes.
Yes.
The one, yes, this one. I had taken notes when you explained the section 29 story. And I think it ties in with this example here. So just for my own understanding, the second use is not covering the usage of the compound directly to treat a different illness, for want of a better expression, but it is covered in the sense that it is used to manufacture a medicament for a different treatment, so for a different illness. So initially,
yeah.
Yes, I'm not sure whether that is understood.
Yeah, I understand. Look, in terms of the way that it's been sanctioned in the Swiss type claim format, that's what it would appear to be, that it's for the manufacture of the medicament for treating a different disease. That is where the focus of the protection lies, the monopoly. But the view is that in terms of section 25(9), it's not really necessary to do that, because it is, in terms of the legislation, it is permitted. You don't need to come up with a method of manufacture of that medicament in order for it to be protectable.
Yes.
Section 25(12) and 25(9) say that that compound, where there's a different use, is protectable.
So the second use approach, as we have it, you say has been sanctioned incorrectly by our courts.
That's what I believe, yeah.
Okay, thank you.
Okay. And as I was saying, in Europe, that they've done away in Europe with its Swiss type claim format as well. And that is likely the way that the South African courts will go if it is ever litigated on in future, because we follow the European legislation quite closely and the findings of the European courts quite closely. Okay, so that then brings us to the exclusions from patentability, as well as the medical method of treatment of animals and humans, and also the first and second medical use of known compounds. Then if we look at the extrinsic requirements, so these are the legal standards that are imposed that an invention must meet. And that is the novelty, obviousness, and it must have utility. So this is again defined in section 25(1) that a patent may, subject to the provisions of the section, be granted for any new invention which involves an inventive step and which is capable of being applied in trade or industry or agriculture. Let's just have a look at the time. Should we break? Is everyone still fine, or it's a lot? Okay. You want to take a break? You want to carry on? Okay, you want to take a break? Okay, I think before we delve into novelty and the extrinsic requirements, the other extrinsic requirements, let's break for lunch. Let's resume then at 1:30. Okay, so for everyone online, we'll be back online at 1:30. We will pick up on novelty. Thank you. For those that are here in person, there is a canteen if you do want to have something for lunch that you can order from. I don't know, Spur and Fisher guys, do you have access cards just to help people into the canteen, please? Thank you. All right. So you can follow the two ladies that need to go to canteen if they want to go. Otherwise, you're welcome to stay here and have your lunch. Yeah.
I want to clarify for myself.
Okay.
For the medical use.
Yeah.
So salicylic acid